If you turn to your handout on page 9, and there are the different standards that are involved. When I said several times in the first segment, you're educating the court. And not only are you educating the court, if you end up having a case like Windland or Shivo, your case could be precedent setting, and so you want to have that in mind, and you want to remember that you might be setting your case up for appeal, and it could end up in either a state Supreme Court or maybe at the U.S. Supreme Court. At page 9 are the various standards. The first standard is a subjective standard. Typically, subjective is kind of touchy-feely, but in this instance, this is the most stringent standard. And so if there's no evidence of the patient's preference when it comes to removing foods and fluids, then they won't be removed. And that is the standard that was used by the trial court in Windland. I don't think that that's what the court called it, but that's what the court used. And that ended up becoming the standard in California with respect to conservatorships. The substituted judgment standard is not quite as stringent, and this is where doing something like removing that descending order of decision makers if there's no directives, why that could be not a good thing, because the trier of fact, and in California it would be a judge, it would be a bench trial. They're hearing testimony about the patient's lifestyle, his preferences, his religious beliefs. One thing that stood out to me in Windland was that his wife was saying, Robert was very fastidious, everything was always perfect. He would not want to live this way because his appearance is not fastidious anymore. I mean, that was the sort of thing that was being argued to justify removing his feeding tube. The last standard is, I think, the dangerous standard. It's the best interest standard. It's the standard that the medical community prefers to use. And it's the standard, what's best for the patient medically. So, what does that mean? If you have several doctors saying, medically speaking, this person will not recover, so let's just let them go, or medically speaking, they have a chronic condition, it'll never get better, let's just let them go. That's the reality of what's happening. I would say that if you're involved in one of these cases and you're preparing your points and authorities, you may not want to specifically mention these standards, but you'll want to argue all three standards, because you want to give the trier of fact, you want to give the Court of Appeal, you want to give the Supreme Court something to hang their hat on. Does that make sense? If you're arguing all three standards, you're not risking that the court's going to say, I don't like this standard, so let's do that standard. You want to argue all three, cover your bases. Does that make sense? So the other thing that I wanted to read or point out to you is on page 8, same tab. Nope, sorry, wrong page. It's page 10. Not only do you want to cover your bases with the standards, you want to, and I'm going to get back to the experts, you want to really grill your own expert, and I'll tell you why. In Robert Windland's case, they kept using the terminology minimally conscious. You and I would call it cognitive disability. And Ronald Cranford testified that the way that he would determine if somebody who was minimally conscious should have treatment or not, which under his criteria is basically no one, he would look at patient well-being, and these are listed on page 10 of your handout. Patient well-being, patient autonomy, integrity of the medical profession, and social justice. This kind of gets back to the guardian in Rachel's case. Patient well-being. If he's looking at it from the perspective of the nurse who said, personally, she's better off dead, then in that medical person's mind, patient well-being is better off dead. If they're looking at it from a traditional ethic where all human life is inherently valuable, patient well-being means give them treatment, get them counseling, and let's get the condition improved. Patient autonomy is one that's used. When I was reading from VACO, they were saying that a patient has a right to refuse medical treatment, and that's repeated a lot in cases. And I would make the argument that conversely, if you have a right to refuse medical treatment, you have a right to ask for medical treatment and you have a right to receive it. If you don't, it turns your right to life on its head. I mean, you have to be able to receive medical treatment if you want it. Integrity of the medical profession. An expert like Ronald Cranford is going to say that it undermines the integrity of the medical profession if they cannot make decisions based on medical standards. Whereas the United States Supreme Court, in considering these issues, said it undermines the integrity of the medical profession to let a third person intervene in your life. And again, I would make the argument that if a medical professional can remove your foods and fluids, it's the same thing. It's just semantics. And then social justice, this proper allocation of resources. I'm pretty sure that if somebody's feeding tube was removed and they pass away, they're not going to rush down the hall with the feeding tube and insert it in somebody else and, give them the bed. I mean, that is just ridiculous. It's absolutely ridiculous. So in using those standards to make the argument that Robert Winland's feeding tube should be removed, we called in other medical experts who said, those standards are great if you're making an assessment about somebody's neurological condition. This is not used to determine whether somebody should live or die. Dr. Cranford went on to say that an unconscious person should have no constitutional rights. So, I go to sleep every night. Do I lose my rights when I sleep? Does a drunk person lose their rights? I mean, that is so, if you take it to its logical conclusion, it's illogical. He referred to Robert as a trained animal. He said that prolonging his existence was, quote, a living death, and he had no right to life because he was minimally conscious. So know your experts, know your standard of care. Somebody just asked me on the break, there had to be more to it in Winland. What was it the wife was after? There was a life insurance policy, but it was virtually nothing. I mean, in today's economy, it was nothing. I think it was maybe $75,000, $100,000. We tried to see if there was another relationship. We couldn't figure it out. There might have been. Maybe she was discreet about it. Again, I think it gets back to people in the right to die movement getting a hold of somebody, and it's kind of like, their cause, and they use that person. Let's move on. I already mentioned Probate Code 3200. This has to do with your appendix with the pleadings. I think they're tabs. I've got it written down in my notes. Appendix C through F. Your petition, your points and authorities, your declarations, your proposed order. This sort of petition or complaint needs to be verified by your client. That's something that's important to remember. You make sure that you provide the proposed order, and if a decision is made, look at your proposed order very carefully. You want to make sure that, here's a good legal term for you, no goofy language gets in there. All these things I've already mentioned. There was a question earlier about what happens if there's a directive and the court still wants to stop foods and fluids. And I want to read to you some language from Washington v. Glucksberg. It was the companion case to VACO. I think there's some excellent language in here that you can use in that instance. It's full of policy arguments that the court really thought out. They must have read somebody's pleadings really well, because I think it's well thought out. The question in Washington v. Glucksberg was the same as VACO v. Quill. It was only it was on due process grounds, and they said there is no constitutional right to no constitutional right to physician-assisted suicide based on due process grounds. Remember that this was prior to physician-assisted suicide being legalized in Washington and Oregon. Washington v. Glucksberg was obviously the state of Washington. They rewrote the statute, and obviously it got passed. It's now legal. But I think that these policy arguments still apply. So the first thing that the court did is they looked at the national consensus on both policy and law. They said that the primary and most reliable indication of a national consensus is the pattern of enacted laws, that indeed our culture has traditionally condemned suicide, and therefore it's logical that they would condemn physician-assisted suicide based on our cultural heritage. And I think that despite the fact that Oregon and Washington have legalized physician-assisted suicide, you can still make that argument, because there are 48 other states. There have been attempts in Massachusetts. I think in Montana it's questionable whether it's legal or not. I know that there's a state senator that says, no, there is no physician-assisted suicide in Montana, and there are others that say, yes, there is. But even though there have been many attempts, most of the attempts have failed. So the national consensus still exists. Something else that they pointed out that I think is key, it says, the prohibitions against assisting suicide never contained exceptions for those who were near death. Rather, the life of those to whom life had become a burden, those who were hopelessly diseased or fatally wounded, even the lives of criminals condemned to death, were under the protection of the law, equally as the lives of those who were still in the full tide of life's enjoyment. So that undercuts the argument that, somebody's had a good life, go ahead and let them die because their quality of life is no longer good.
What page are you on?
This is not in your handout, but this is, and for those of you who want to read the case later, this is Washington v. Glucksberg, and the citation is 521 U.S. 702. And if you're here and you're not a lawyer, if you just Google Washington v. Glucksberg, it'll pop up. You'll be able to read the case. And I would highly recommend that if you're going to be involved with these cases as an attorney, that you know these cases backwards and forwards, because they've got some excellent language in them. And again, it's about physician-assisted suicide, but I think we can make the analogy that that's precisely what removing a feeding tube is. It's a third party being told, take this step and don't give them foods and fluids. So it says that the 14th Amendment forbids the government to infringe fundamental liberty interests no matter what process is provided, unless the infringement is narrowly tailored to serve a compelling state interest. And it almost sounds like the court's going to say, and I think this is narrowly tailored enough, but they don't. They say that to hold for respondents, who were the people that were advocating physician-assisted suicide, we would have to reverse centuries of legal doctrine and practice and strike down the considered policy choice of almost every state. Do you hear that? Where was this court during Roe? I mean, constitutional scholars who are pro-abortion say Roe is a bad decision because that's precisely what Roe did. But this court didn't. This court got it when it came to physician-assisted suicide. And now we get into what are the state's interests exactly in preserving life and saying that there's no right to physician-assisted suicide. The state, they hold, has an unqualified interest in the preservation of human life. I mean, it just seems so obvious, and we have to go to the United States Supreme Court over these issues. The state has an interest in preventing suicide and in studying, identifying, and treating its causes. That comes back to counseling and getting proper treatment for people that are suffering from depression. It's not the easy way to do it, but aren't human beings worth it? And then if you come from a faith-based perspective, whether you're Catholic, Jewish, whatever your faith, we are created in the image of God. We are his image bearers, and we have to have that in mind. And if you're a person here who's not a person of faith, it doesn't matter. All human life is inherently valuable. And if you're not somebody who believes that you're an image bearer of God and that God is the one that decides when you live and when your life ends, then you can make equality, sanctity of human life arguments. You could analogize to saving the whales or saving, the eagles or whatever. I mean, human life is inherently valuable, and that argument needs to be made. In this particular case, this was the state of, it wasn't the state of New York, it was Washington, but they were citing from a state of New York task force that considered this issue. And they said that depression is difficult to diagnose. Physicians and medical professionals often fail to respond adequately to seriously ill patients' needs. So again, the idea that if the medical professional is doing a good job, they're going to adequately respond to those sorts of issues. This is great language here. The physician-assisted suicide is fundamentally incompatible with a physician's role as healer. And I think somewhere in the decision, either Washington or VACO, they say, we don't want to put the physician in the position of being a harmer rather than a healer. And this is something else that I don't think people are aware of. Many physicians today no longer take the Hippocratic Oath. So it's a good thing to ask your physician, did you take that oath? You should know that. Allowing a third party to end somebody's life would undermine the trust that's essential to the doctor-patient relationship. I can tell you that I've seen a number of cases where family members are not comfortable going home and leaving their loved one in a room if they have a feeding tube, because that relationship has been undermined because it's become so confrontational. You need to advise your clients that when you're dealing with something like this and you're involved with the medical staff, you need to really pick your battles, because I've seen cases where they've had family members forcibly removed from the hospital and they're not allowed to come back. So, these are not things that I've seen a lot, but it does happen. It's kind of like social workers, people who have the authority to take your child out of your home. You want to pick your battles. You want to make sure that you're being respectful and polite, and you don't want to create you don't want to put them on the defense right away, because what I've found is typically people with power use power, and if they get irritated with you, it won't be for your good, it'll be to your detriment. The next policy argument was that the state has an interest in protecting vulnerable groups, the poor, the elderly, the disabled. And they're saying that the state's interest extends to protecting disabled and terminally ill people from the prejudice, negative, and inaccurate stereotypes. They call it societal indifference. I have to confess that there are occasions when I'm around somebody with really severe disabilities and I'm really uncomfortable. I don't know how to interact with that person. We need to figure out how to do that. They may not be fully able, but they're human beings with active minds. Case in point is that gentleman who could hear them talking about him, treating him like he's a piece of furniture. He could hear what was going on. So we need to be aware of that and make sure that we're not participating in that societal indifference. And they say, finally, the state may fear that permitting assisted suicide will start down the path to the voluntary and perhaps involuntary euthanasia. Now, these statistics are rather dated, but I'm pretty sure they've only increased. And what the court did is they considered statistics from the Netherlands. We hear all the time when people are in legislatures promoting physician-assisted suicide, we'll have safeguards. We'll make sure that they're consulting with a physician, and then they get a second opinion, and all these so-called safeguards. Those safeguards exist in the Netherlands, and here are the statistics. They're pretty chilling. This is a 1990 study. There were 2,300 cases of voluntary euthanasia, and they define it as the deliberate termination of another's life at their request. There were 400 cases of assisted suicide, more than 1,000 cases of euthanasia without an explicit request. In addition to those 1,000, there were 4,941 cases where physicians administered lethal morphine overdoses without the patient's explicit consent. And they go on to say that the study suggests that despite the existence of various reporting procedures, euthanasia in the Netherlands has not been limited to competent, terminally ill adults who are enduring physical suffering, and that the regulation of the practice may not have prevented abuses in cases involving vulnerable persons, including severely disabled neonates and elderly persons suffering from dementia. On the subject of neonates, there are people who think that until a toddler is of a certain age with their brain function, that the parent should have a right to end their life. Dr. Peter Singer, our own president, voted against legislation with that kind of thinking. So we, ladies and gentlemen, are involved in a battle, and you're part of it. You're here today. I hope that that you'll really seriously think about getting involved in this attorney network. So what I want to do is sort of make a pitch, I guess, for really considering this in your professional career beyond just coming and getting continuing legal education credits. We need a network of attorneys who are willing to step up and handle these cases. And I can tell you from experience that even people who are pro-life when it comes to abortion, I had several people walk up to me at an event when Robert Winland's case was going on, and they said, "Why are you bothering with this? He should be allowed to die." And these are people who would never think of having a child killed, an unborn child killed. So there's a real need for this. And again, not only Obamacare, I mean, the private healthcare system is rationing and making decisions based on their so-called, scarce resources. So this is a really serious issue, and I hope that you'll be willing to be part of this network. I'm going to go through my notes to see if there's anything that I want to add to this, but I guess what I want to do now is open it up for more questions if anybody has any. Is everybody clear on procedurally with the petition, the points and authorities? Those are in your appendix, A through F, I think it is. No questions. How many of you here do, yes, sir?
That Bacco case and the Gluckberg case, they're they're still the law of the land since they're U.S. Supreme Court cases, or have they been chipped away at the state level?
Well, what the court did in Vaco and Glucksburg, the question was, are they still valid because they're U.S. Supreme Court cases, and have they been chipped away at the state level? Probably, but the way that the legal system works is you have certain rights. And if your rights are impinged, unless you're the person bringing the legal challenge, they'll continue to be impinged. So that doesn't mean that it's not still good precedent. That just means that legislatures are, getting away with it until somebody takes legal action. What the court did in Vaco and Glucksburg is they basically left the issue to the states. They said that state legislatures were better equipped to consider all these various policies and what would be involved if physician-assisted suicide was legalized, and so they left it to the states. So yes, I think it is still good law, and in fact, the state of Washington had to go back and redraft their particular statute that allows physician-assisted suicide. Yes?
Dana, these documents are a great service to us. Do you have them so we can download them so we don't have to retype them?
Actually, if you were to send us an email, we could get them to you so that you don't have to retype them. And in fact, what am I thinking? Eventually, we will have this online, this videotape online, and the resources will be available online. But in the meantime, if you need them, we can get them to you. Any other questions? Yes?
You had mentioned that those without a directive, that the probate code had changed to delete the procession of those who can
Yes.
Give authority. So then how are the hospitals handling that?
Well, how are they handling them? They typically do go to the spouse, but what will happen is if they don't like what the spouse has to say, they'll try to find somebody else. So they'll go to another family member. And if they can't, then it might become a battle between the family and the hospital. And that's the petition, the model petition in our handout is designed for that event.
When did that change?
That changed in 1999. Yes.
With respect to the expert witnesses, this Dr. Cranford, I assume that he was used often by these people who were trying to put these people to death?
Yes, Dr. Cranford has a long history in the cases where they're advocating for death, and it started, I believe, there could have been one before it, but the primary one that I know of is Cruzan. And that, I mean, years and years he spent being an expert in these cases. And Cruzan was the first case where they allowed the feeding tube to be removed, and it was at the request of her father, and the court made the determination that that's what she would have wanted. So
one of the things that struck me with the testimony was the lack of references to prior testimony and using that to discredit him. It would seem that if Dr. Cranford had testified a number of times before, transcripts of that would have been used to essentially set him up to discredit him on the witness stand. I'm guessing that Mrs. Cease was not had not done a lot of litigation prior to this.
that was Miss Cease's first trial. Can you imagine? And not to say that she didn't do a good job. She did an excellent job. But it's part of the process as an attorney. I'll give you an example. When I got out of law school, I was working for somebody who was an attorney that had never been in court, and he was supposed to be my supervising attorney. And if I had not clerked for a criminal defense attorney for 2 years, I probably would have, I don't know what I would have done. I started to say ended my life, but that's not funny in this context. I mean, it was awful. But I got the job done. It just makes your job really, really difficult. So it was her first trial, and she was working for a firm that didn't necessarily think it was an important case. And so that's why it's good to know Life Legal's around, because we were able to give her support, moral support, legal support. We helped her find experts and did all those things. It just was, and I have to say that Winland was a case of first impression in California. So not only was it her first trial, it was a case of first impression. And I think this is why we have such a problem in our culture. I'm going to kind of get off the track here, but people just don't like to, they don't want to be uncomfortable on any level. And so to step out as a lawyer or a medical person and do something that's totally contrary to what everyone else is doing, it's kind of like peer pressure, only you're not junior high anymore. And and what's unfortunate is people don't want to be uncomfortable, and we're talking about people's lives, and we need to be willing, especially if we're faith-based people, we need to be able to be willing to make some sacrifices. I'm pretty sure some sacrifices were made for us, and we need to reciprocate. If we're people of faith and we're modeling Jesus Christ, we're going to sacrifice regardless of what it means.
The other thing I noticed is that with respect to lexicon, that's a little bit arcane to most of us. Doctors love to do it. Lawyers love to do it. So do engineers and anybody else. The thing that stood out to me with the examination also is that when you get a strange term thrown at you, you just simply ask them, well, what does this mean? And then you go back to your line of questioning.
Right. And that, maybe Janie knew what titrate meant. I had to look it up.
But he may not know.
That's
what he
true.
thinks
He could
knows.
just be spouting, something rote.
Okay, so it's 11 p.m. on Friday evening, and I am at the wonderful Stanford University Hospital.
Yes.
And they want to pull the feeding tube out of my mother or grandmother. Let's say my grandmother. Mm-hmm. Okay. What do I do? Because how do I get to the court and get the petition and everything? Because it's Friday night, 11 p.m.
Yes, and I'll tell you, I don't think that it's any accident that a lot of these cases happen on a Friday night. There are courts where you can file emergency petitions, so you just need to know your local courts. I don't know if that's true in the Bay Area. I don't even know if it's true in Sacramento where I used to live, but there are courts where you can file emergency petitions.
They would be open at 11 p.m. or 11:35?
Yeah, and I say that in cases where I've seen, unrelated to this issue, I've seen them filed, and it's typically at the Court of Appeal level. So I don't know if that's necessarily true at the trial court level. I don't know if there are any litigators in here that have been able to file emergency petitions, but I know we had a case in Birmingham where we were able to file an emergency petition with the Court of Appeal late in the day on a Friday So, sometimes it's just knowing who the judges are. Sometimes you can go knock on the judge's door. But if you're in a big city, that's not as likely to happen. So, if this were to happen on a Friday night, the first thing that I would do is I would try to send some sort of a demand letter to the caregiver, to the hospital, whoever, and then hopefully your client has contacted you in time. It's like that gentleman that I mentioned earlier, the grandson. He waited until 8 days into being unconscious and not fed, and it was too late. Do you have another question?
I do, but I don't want to hold up. Okay, my other question would be, what if this is getting off point, what if, like, for example, I know this happened to a friend of mine, they told her, we're not going to, at Stanford, we're not going to let you see your grandmother as she's dying unless you, let us, take her off the respirator or something like that. So what do you do in that sort of situation?
The system is only as good as the people that are in it. And in that situation, I don't really know what you do other than try to go to the court. And I have never encountered that situation in the court. I'll tell you, for example, Terry Schiavo's case, her feeding tube was removed 3 times before the 3rd time was the final time. And when she died, they had law enforcement in the room, and they would not let her parents go near her. What can you do? You can't do anything. And that's why I was mentioning earlier that you need to you just need to be prepared as best you can. And there are just some situations where it's out of your control and there's nothing you can do.
I guess the only other thing I might say is that may be where, like you were saying, your point before, it's very difficult because you are dealing with these evil people sometimes, but is just to keep polite, because sometimes that can still save you a little bit. And
yes, and that actually was my thought, and it left my brain. Again, the cognitive functioning. That's why you need to be extremely polite and professional and respectful, because you're going to have a better chance. And something like that is not as likely to happen if you've done that. Did you have a question?
Yeah, Dana, it seems like there's a philosophy that permeates the country, this kind of false thing that says, I don't want to be kept alive by machines.
Yes.
And what people don't realize, of course, is that when they say machines, they really mean including feeding tubes and hydration equipment. And a lot of these advanced healthcare directives are, kill me first, and then you just, they ask the people just initial this place, and it says, I don't want any treatment whatsoever.
Right.
Keep me comfortable. And it seems like we've got a major problem in education. Even, say, if I'm an attorney going to someone and they immediately tell me, I don't want to be kept alive by machines.
Yes.
And so I've got a moral dilemma to convince them, and how much time are they going to give me to talk to them about it? And so the attorneys have a problem. What do you do if someone is asking essentially that to sign a document that they want to be killed? And so do I not help them do that?
I would say that that's a perfect. We're counselors at law, and it's a perfect opportunity to counsel. I wouldn't hesitate. I know. Conversely, when my husband and I did some estate planning, a trust for our property, we went to a lawyer at our church. He's an Orthodox Christian, but he's not educated on these issues. And he said, well, let's go ahead and do a directive since you're in here. And he gave us the standard directive out of the California Probate Code. And so I use that as an opportunity to say, hey, guess what? You need to tweak this a little. So yeah, I would definitely take the opportunity to educate. And it's like anything. Some people, they're not going to believe what you say, or they're going to, they may believe what you say and they may not care. But you just have to do what your conscience tells you to do and try to educate them, because then it's up to them. And you just hope and pray that they won't make the decision that's going to put them in the situation where they're being dehydrated and starved to death.
I guess the good news is that most people, there's so much paperwork, they'll sign whatever you give them. And so I always give them the Steubenville anti-euthanasia task.
Yeah,
they've got a new name now.
It's Patients' Rights Council.
Yeah. But if I give them that and say this is a real good one, and my wife and I have it, and they'll usually sign it. I mean, I tell them to read it, but I have no idea whether they're really seriously considering it.
Mm-hmm. That's a good point. You had a comment?
Yeah, I had a comment on the what do you do with the client who comes in and who's looking to sign one of these directives and really doesn't know. I think the attorney needs to know what's really going on to some degree in these facilities. My mother went through she had a stroke and died after being in the hospital after 7, 8 days. So when you look at the equipment, they feed you, they give you water, they have you on a ventilator. Most of the other stuff is monitoring equipment. It's not like a Frankenstein's monster where they're artificially keeping the body and making the heart pump and all that. It isn't quite that. And so it's probably useful for the attorneys to at least know what's there, and then you can talk to the client and explain to them what the process really is. And then if they make that informed decision, you can make you can say, well, I can't go along with that, or you go along with it. That's your conscience.
Mm-hmm. That's a good point. So I guess what I want to reiterate is that we're dealing here today with the issue of foods and fluids. And I know there may be people in the room that disagree with me, but if something is truly artificial, if somebody's in a coma and the only thing keeping them alive is a ventilator, we're not advocating that person should be kept alive. That's a decision that's truly up to you. Yes, an individual has a right to refuse foods and fluids. That's absolutely their right. The courts have said you have a right to refuse medical treatment. So we're here to let you know what that means legally, what that means morally, ethically, and hopefully as attorneys, you'll use your position as attorney at law, counselor at law, to really advise your clients well, because this is the kind of practice of law that it means somebody's life or death. And that's sort of been the philosophy of Life Legal. We have this little saying, no case too small. We've done lots of cases like this that didn't get the notoriety of Terry Schiavo, but you know what? That person who's alive really didn't care if their case was precedent setting or if they got notoriety. And the same is true with any of our cases. A sidewalk counselor doesn't care if their case is precedent setting. They just want to be able to say what they want to say and not have to go to jail. So anyway, any more questions before we close for the day? We're going to be done about 10 minutes early, so we have time for questions. And if you're an attorney who's, yes, sir.
I'm just looking for a good summary of the effects of the agony of the person goes through. And so far, it looks like on your tab 5, where your Wesley Smith is quoting Dr. William Burke. Is that
Yes.
a good place to go? Because I'm thinking personally where I'm convincing a daughter to be to make those decisions for me, that can sure, hey, this is actually what goes on if I don't get water and food.
Yes,
That's something concrete rather than for me to sit there and talk
and
in
describe
vague generalities. And something that's also, and notice that it's it's a doctor, so it's you can look at it.
It gives it more validity when it's coming from a physician. Yes.
If you're looking for, actually what I'm looking for is something that it would be, what would you use as the most convincing thing to give to someone that's a lay person that knows nothing about medicine or about this subject?
I would, and Kevin may have some books to add to this, but I would highly recommend that they read Forced Death by Wesley Smith, and the second book, The Culture of Death, which it's cited there in that little box. That's his second book that talks about the assault on traditional medical ethics. Those are where I would start, and I'm not sure if...
So it's forced what?
Forced death.
Okay.
Forced death. And the other thing that I would recommend is I mentioned earlier that I would advise you to go to your own physician. I was at a doctor's appointment one time, and was when the Winland case was going on, and I was telling my physician what was happening, and you could tell by the look on his face he thought I don't know what he thought, me, she's lost her mind. This can't be happening. And so I just kept having the conversation with him, and he finally, something that I said convinced him, because you could see his countenance change. So to add to that answer to your question, if you have a family physician, go to them. It's somebody that your daughter might know and say, you know, can you confirm this for me? And ask them what they would recommend, medically speaking, to show her as far as the process. Because you can kind of kill two birds with one stone. You can find out what your doctor really thinks, and you can get something to give to your daughter. Any other questions? Well, thank you, everybody, for coming. If you are an attorney and you want to stay for another few minutes, we're going to be meeting briefly, talking about what we're going to do with this attorney network and where to go from here. So if you have the time to do that, we'd really like you to stay. And thanks for your time today. And if you ever have a case like this, whether you're a lawyer, a non-lawyer, and you need help, please call Life Legal. We have an attorney network, even if it's in, you know, Kansas or wherever. We have an attorney network, and there's never been a time when we've not been able to find an attorney through our network. So please call us if you need that kind of help. Yes, ma'am. We do have extra binders, yes, and you're welcome to have one of those. Okay, thank you.